Well, good morning, everybody. We'll go ahead and get started. We may have some latecomers. Appreciate your coming in to hear about changes in the Montana employment landscape and the United States employment landscape and labor law. Those of you who follow the national press have probably heard quite a bit in the last few years coming out of the United States Department of Labor. I am Richard Miltenberger, as I may have mentioned a second ago, but I'm in employee benefits as my profession, and I have found over the years that intertangles me with the whole broader issue of human resources and bargaining units and labor. But I'm a bit of a neophyte at it, so I've been chosen to moderate rather than to speak. So I'm glad for that. We have two terrific panelists this morning. I'm personally very interested in this topic, and they're from very different perspectives that I don't think will overlap. We'll hear first from Glenn Spencer and then from Connie Kullbeck. Glenn is, I'm going to say you're from the D.C. area just because I think you are. Good.
Close enough.
Good, yeah. So Glenn is flown in from the meeting, We appreciate your taking the time to get out to Montana. Glenn will go first, then Connie. Just by way of introduction, and there is a bio in your packet, but Glenn was Chief of Staff to Elaine Chao, Secretary of Labor under the Bush administration, and is now at the United States Chamber of Commerce and is in charge of a project that I thought I would remember, and of course I'm forgetting. What is the name of it? It's a Workplace Freedom?
Workforce Freedom Initiative.
Workforce Freedom Initiative, which I think pretty much says it all. So eager to hear what Glenn has to say, and then we'll have time for Q&A after Glenn's talk, and then Connie will speak Q&A there, and then a little bit of Q&A at the very end if people still have questions for them combined. We'll try to get you out of here early, if not early, at least on time. So again, without further ado, Glenn Spencer.
Thank you, Richard. We heard a little bit yesterday about how the Environmental Protection Agency is making things difficult for Montana. Unfortunately, I'm here to tell you they're not the only federal agency that has the potential to make things difficult in the state of Montana as well. So what I'm going to talk about is mostly federal issues. It's going to be the National Labor Relations Board, Department of Labor. These are entities that are changing the law in very, very important ways that I think employers need to know about, but they're not doing so through changes to law in Congress, right? They're not making legislative changes. These are all regulatory changes, which is why I refer to these agencies as regulators on the loose. I think by the time we're done with this presentation, you'll get the same sense that I have, that these are very dramatic changes in labor law, and that even if you are not a unionized employer or have a union campaign underway, these are things that will impact your business. So they're very important issues that all employers need to know about. And the reason for most of these changes is fairly simple. It's all on this slide here, which looks at the rate of union membership. And as you can see, it's declined fairly precipitously over the past 60 or so years. This is a big problem, obviously, for organized labor itself. They need to recruit new members, but it's also a problem for the administration as a whole, because frankly, the Obama administration views increasing the number of union members as key to their economic goals. They talk a lot about income inequality, stagnant wages, decline of the middle class. They view increasing union membership as a key to taking on those challenges. So again, it's not just the unions that are worried about this, it's the administration as a whole. So they look to government as a solution to those challenges, and they're doing so through two agencies. One is the National Labor Relations Board, as I mentioned. I don't know how many people in here are familiar with this organization, so I'll just do a quick background on it. This is a small agency in Washington, D.C., a couple hundred civil servants that work there, but then the real players are the five-member board itself, which acts almost as a Supreme Court in the field of labor law, and then it's the separate general counsel's office at the board, which acts in a sense as the prosecutor. That's who actually files charges against employers, and then the board will ultimately hear those. These are political appointees. They are all five members of the board, and the general counsel are nominated by the president. They are confirmed by the United States Senate. Right now, there are actually four members on the board. One of the members' terms has expired. I don't think we'll see a new nominee during the remainder of the president's term, so we might have to wait until 2017 to get that board back up to five members. But the key thing is this, and at the U.S. Chamber, we try to be as objective as we can, but there really is no way to sugarcoat this statement. The majority of the board and the general counsel simply has a bias towards unions, and that's certainly a valid opinion to have, but unfortunately they are using that bias to make some fairly dramatic changes in policy. We'll talk a little bit also about the Department of Labor, which again, under its relatively new secretary, is also making some fairly dramatic shifts in policy. The one we'll talk about today is the overtime issue. So within that context, here's what we'll discuss. We're going to talk about the ambush election rule, which is a new regulation the board finalized last year. The joint employer standard, which is a pending issue. The board has decided a case in this area, but we haven't seen it broadly enforced yet. We'll talk about employee handbook cases, and this is one that certainly can impact you whether you've got any kind of union presence or not. We'll talk about the micro-union issue, and then finally, as I said, we'll talk about the Department of Labor's pending overtime regulations. Okay, so first, the ambush election rule. This rule actually went final last April, so it is now in effect. This is what the National Labor Relations Board is using when it conducts elections. And the simple purpose of this rule is to speed up the time frame for those elections to take place. Under the previous rule, elections could take place in about 38 days, right? That was sort of the average time frame. And that means that from the moment that the union says to the federal government, hey, we'd like to have an election at workplace X, and the time that the government actually holds that election would be about a month, 38 days or so on average. And what that did, that time period, was it allowed employers to make their case to employees, right? It allowed the employer to give information to employees about the potential impact that unionizing a business might have. Well, the board did not like that, frankly, because a shorter time frame allows for a higher win rate for unions, and because they thought that employers were using that window to really shape employees' views in a way that was not appropriate. So they put this rule into place, and the intent was to drive down that time frame. Potentially it's as low as 10. We have seen elections take place in just 10 days. The average now is about 23 days. Now what that means for employers, just a simple show of hands, how many people in this room have read the National Labor Relations Act? Okay, nobody. So you don't really know what the restrictions are when there's an election in place, and there are a number of restrictions on what employers can do or say, and they are not intuitive, right? You might think it makes perfect sense that I could say that this would harm my business, or that our revenues might go down, or things like that, but there are very strict limits on what you are allowed to say and do, and if you don't know what those are, you can wind up in a fair amount of trouble. The other thing is, how many of you have labor counsel on staff? Okay, actually 2 of you do have labor counsel, so you're in a little bit better shape. But for those who don't, think about that 10-day window. Okay, you find out on day 1, hey, I've got an election coming up. I need to start doing things. I don't know what I can do or say. I need to find a lawyer. It's not always easy to find good labor counsel, so you have to spend some time doing that. Then when you find one, you've got to figure out, okay, well, he's going to tell me what I can do or say, and suddenly that 10-day window is done. Right? And you have not yet gotten around to talking to your employees about your view on the matter. And your view on the matter might be, hey, that's great, let's unionize. Your view might be something different, but you have lost that opportunity. So that was really the board's intent, is to drive down that time frame. Now, the second thing that this rule did, or does, I should say, is it restricts employers' legal rights. And it does that in 2 ways. The first is that under this rule, you have to submit what they call a statement of position, and you have to submit that within 7 days. That statement of position, which you submit to the NLRB, lists all the issues, all the legal issues that you might raise during the course of that election campaign. Anything you don't include in that statement of position, you waive the right to raise it later. Now remember again that 10-day window, that you don't have a lawyer yet, you don't know what's in the act. Well, how are you going to know what to put in your statement of position? But you've got to do that within 7 days, and again, if you don't, you waive the right to raise those legal issues later. Now, at the back end of the process, it also restricts employers' rights, because at the end of an election campaign, you might have seen some issues that you think merit review by the board. Maybe there was some improper conduct, maybe people who shouldn't have voted actually did vote, and at the end of that campaign period, or at the end of the election under the previous rule, you could raise that with the board itself, that 5-member board, and they would have to hear an appeal. Well, now that's completely optional. They don't need to hear that if they don't want to. So regardless of what conduct you may have seen, you may not get a chance to raise those issues and get them resolved. So it restricts employers' legal rights as well. Now, issues of voter eligibility, those can be dealt with after the election has taken place. You may have a question about, well, is this person really a supervisor, or are they an actual employee? Should they be voting in the election, or should they be on my side, helping me get my point of view across? Well, those issues don't necessarily have to be decided before the election anymore. The board has said that they will push questions of voter eligibility after the election period. The idea is to vote first, ask questions later. It's a little bit ridiculous in my view. That'd be like having a congressional election before you knew what the shape of the district was. I guess here that's not so much of an issue, but think of it in other states where you have multiple congressional districts. If you don't know what the shapes of those districts are, how can you have an election when you don't know who the voters are? Well, that's kind of what the board is doing here. This one always gets employers riled up, and frankly workers too. The fact that under this rule, employers have to turn over personal information about their employees to union organizers, and that includes obviously their names, home addresses, phone numbers, personal email accounts, shift locations, work schedules. All that type of information needs to be turned over to the union within 2 days. And in fact, the board has overturned election results based on the fact that an employer had not provided 100% of that information. So if you've got a large enough company, you may have different departments, and those different departments may have their own list, but the boss at the top may not have all that. Doesn't matter. If it's not all turned over, the board can and has charged employers for violating the act because of that. Now, I often get asked when I raise this point, well, do employees have the option of saying, hey, I don't want my information disclosed, right? Is that a choice that they get to make? And the answer is no. It is mandatory that this information be turned over to the union within 2 days of that election petition being filed. So bottom line with this, it's meant to limit the time that you have to respond to an organizing campaign. It's meant to cut that down. And again, we've seen it as few as 10, but again, on average 23. And then obviously it's intended to prevent you from getting balanced information to your employees. Again, this rule is in effect now, so this is how the board is conducting elections. Okay, the joint employer standard. This is an issue that has the potential to affect you whether you've got a campaign or not. Whether you've got a union or not, never had a union, doesn't matter. This issue can impact the way that you do business. And if you remember nothing else about it, simply remember this, that the NLRB is attempting to make you liable for people that you don't employ and for workplaces that you don't actually control. That's what's going on here. It's taking place really on 2 tracks. So first you've got the general counsel. Remember, that's that separate entity of the board that brings charges, and the general counsel has filed charges against McDonald's Corporation, alleging that it is a joint employer with its franchisees. Now, as we know, franchises are separate businesses. They are separate legal entities from the larger corporation. Well, the board is trying to blur that distinction and water it down by charging McDonald's and claiming that McDonald's actually has enough authority over those franchisees that it should be considered a joint employer. Now, the second track for this is on August 27th of last year. The NLRB issued a decision in a case called Browning-Ferris. And what they did with that decision was they replaced the long-standing and very easy to understand direct and immediate control standard with a much vaguer standard based on potential to control and indirect control. So what do I mean by those? Well, the direct and immediate standard simply said, look, if you are not involved with hiring, firing, paying benefits, discipline of another employer's workers, you're not a joint employer, right? Pretty simple. I mean, think of a temp agency. That would be an example where you probably are a joint employer because you are sharing those direct and immediate control factors. But under this new standard, joint employment status could be found in a wide variety of business relationships. Let's think about the indirect control standard. Let's say I've got a office building that I own. I'm going to hire a janitorial subcontractor to come in and clean it, right? Chances are I don't actually have janitorial staff as part of my employee base. So I go out and I hire a subcontractor. It's a very, very common arrangement. One of the things I may do is say to the subcontractor, look, you do all the hiring. I mean, I don't want to have anything to do with your employees, but to say that don't come in before 6 p.m. and make sure you're done by 7 a.m. because I obviously don't want people cleaning offices while people are trying to work. Well, what I've done under this new standard is I have now established indirect control over the terms and conditions of at least one piece of the employment relationship, right? And that is the hours of service. If those janitors wanted to negotiate about hours of service, they probably won't be able to do it unless I'm sitting there at the bargaining table with them, because I have that indirect control. Under the board's thinking, that it now makes me a joint employer. I now share liability with that subcontractor. The potential to control standard is actually a little more disturbing, and this actually was an issue in the Browning-Ferris case itself. Browning-Ferris, they run a garbage disposal facility or waste disposal facility, and they would subcontract for employees to come in from time to time. If there was a surge in business, they might need some extra employees for a temporary period of time, so they had a contract with a labor services provider. Now, that is also a fairly common relationship. But any employer that does that is going to put something into that contract that says, we retain the ultimate authority to say who gets on our work site and who doesn't. And you do that simply for liability purposes. You don't want people coming on there who are selling drugs or drunk or have guns. I mean, you probably don't want those people on your work site. So you're going to retain that ultimate control. Well, that is the potential to control, because the ultimate term and condition of employment is being able to show up for work. And if you are reserving to yourself the ability to kick somebody off the work site under this new standard, that makes you a joint employer. So you now have joint responsibility and joint liability with that other employer. Therefore, you could see joint employer status found in a wide variety of business relationships, from franchising to subcontracting, potentially even with vendors and suppliers. This standard is very vague. We don't know exactly how broadly the board will apply it, but based on a reading of that case, we think it's going to be fairly broad. And again, this can impact you whether you've got a union or not. You could find yourself in a joint employment situation. Now, why does it matter? Well, let's say you retained a unionized subcontractor. Well, you are now going to be party to that collective bargaining agreement. You're going to have to sit down at the bargaining table and negotiate over terms and conditions of employment and be bound by the terms of that contract. That's really the danger here. The other danger is simple litigation, right? Because if you are, I'll get back to that bullet in a second, but if you are found to be a joint employer, you now are sharing joint liability. You can be potentially sued because of that relationship. And we're already seeing that, we're starting to see that happen. There was a case in Chicago, a hotel franchisee had a sexual harassment issue. The lawyer didn't just go after the franchisee, they went after the brand name company as well, because he said that they shared joint liability under this new standard. Bullet here that I just skipped over. What the board is doing here essentially, is trying to assist the Service Employees International Union in an organizing campaign they've got going on against McDonald's. You might have heard about Fight for 15 protests, fast food restaurant protests. That's what this is all about, right? The board is attempting to make it easier for the SEIU to organize McDonald's and other franchise restaurants in the fast food industry. Now, as we know, fast food is just one sliver of the franchise industry. And the franchise industry is just one sliver of the larger economy, but this rule has the potential to impact everybody. So there is a lot of collateral damage that could come out of this. All right, handbook cases. Again, this is one that applies to unionized employers and non-unionized employers equally. Whether you've got a union, never had a union, doesn't matter. The board can enforce these handbook cases on you, and we have seen them enforce these issues all over the country amongst numerous employers. So this is all based on the concept of concerted activity. Okay, under the National Labor Relations Act, federal statute, workers have the right to discuss wages and benefits and work rules and talk about joining a union if they want to. And as the employer, you can't tell them not to do that. That would violate their rights under the National Labor Relations Act. But there is a little bit of a gray area there. What if one of your handbook policies doesn't on its face say you can't do those things? Like, for example, if you had a handbook policy that said we don't have unions here, pretty obvious that's going to be unlawful, and I think most employers get that. But what if you've got a policy that's not so clear, but an employee potentially could read it as meaning to interfere with their ability to exercise concerted activity? Well, the board looks at those types of cases and says, hey, would a reasonable employee read a rule that way? And if that's the case, in their view, that a reasonable employee would think you were trying to restrict concerted activity with a handbook policy, they will find it to be unlawful. Fairly simple. It's worked okay for a decade or so. But this board seems to have a very different definition of reasonable. It's a definition most reasonable people would not find reasonable at all. It's a very unusual definition. So the board has looked at this, and they have found a number of common sense policies to be illegal for violating employees' right to engage in concerted activity. Things like requiring courtesy in the workplace. I mean, for most of us, this is a no-brainer. It's just common sense. You want your employees to treat each other and customers and managers with courtesy. But the board has found these types of policies to be unlawful if they are not worded in a particular way. So a number of employers have found themselves tripped up over this issue in their handbooks. Most employers would prefer that workplace investigations remain confidential. In fact, other federal agencies would like to see a lot of workplace investigations, particularly around issues of sexual harassment. They would like to see those kept confidential. Well, the board has a different view of this. Their view is that if you are going to request that employees keep a workplace investigation confidential, you must have a very, very specific business reason why you need to keep it confidential. You need to document it very carefully, and you need to be able to satisfy the board that your reason for wanting to keep it confidential is appropriate. We have seen numerous employers get into trouble over just telling employees at the start of an investigation, hey, can you please keep this confidential? Numerous employers have found themselves in violation of the act because of that. Most employers would like to protect confidential information, and most employees would like to see their confidential information protected as well, but again, these are policies that have run afoul of board law. They have found numerous employers guilty because of these confidentiality provisions. There was a case involving Boeing. They make airplanes. I think everybody's heard of Boeing. I think they sponsored part of this conference. One of their factories, they had a policy that said, hey, we don't allow cameras in here. And that's for the obvious reason they don't want people walking around taking pictures of their manufacturing processes. Well, the board actually struck that down and threw it out and said, no, you cannot tell employees that they cannot walk around with cameras. And finally, dress codes have gotten employees or employers tripped up as well. There was a case with a company that helped refurbish cars, and they didn't want employees wearing pins because they were worried the pins potentially could fall off and then rip leather seats and that kind of thing. The board actually struck that down too and said that they could not keep that type of dress code in place. So all these types of issues, and we could go on and on about more common sense policies that we think are common sense, but that the board has thrown out. Bottom line here is if you haven't read your employee handbook in a while, you might want to go back and do that. Some of the things in there that you think are completely common sense may not be, and you may see them in a different light after this. I was giving this presentation at one event in California, and somebody asked me, well, so what, right? I mean, so they strike down a provision in my handbook, that nobody goes to jail for violating the National Labor Relations Act, and the penalties are fairly small, and that's all true. But think about it this way. If you get tripped up on one of these handbook cases and you're found actually to be guilty, you've now been found guilty of violating a federal statute. And I don't think too many people would want to have that on their record. Second thing to think about is if you get tripped up on one of these handbook cases, you're otherwise a completely law-abiding employer, but you get dinged with one of these, and down the road somewhere you actually do have an organizing campaign, the board can use that violation to have a rerun election in the event that the union might lose. And we have seen that happen. So, yeah, the penalties under the Act are fairly small. Yes, nobody goes to jail for it, but it really can trip up your business, so it's something you need to think about. Micro-union issue we'll do very quickly. This is based off a 2011 decision called Specialty Healthcare. Basically what the board did here was they rewrote their standard for what makes up a bargaining unit, right? When the union holds an election, that's what they're trying to do is form a bargaining unit that they will negotiate for. Well, under the previous standard, prior to 2011, the board tended to look at larger units, right? Let's say I had a retail establishment, there were 100 people that worked there. The board would look at that and say, here's your bargaining unit, right? It's 100 people. So if the union wanted to win the election, they would need to win over a majority of that large unit of 100 people, or at least a majority of those who showed up to vote. Under this new standard, that's been changed. So the board is now essentially saying that the union can pick the composition of the bargaining unit it would like. So they might go into that same retail establishment of 100 people and say, okay, no, we don't want that. We just want the 5 guys that work in the loading dock, okay, because we already know those 5 guys support us. So we'll go in and make that the bargaining unit, and that's where the election will be held amongst just that small number of employees. Makes it much, much easier for the union to win. And of course, it makes it easier for them to enter a workplace where a majority of employees may not wish to unionize. That's the whole intent here. As I say, it makes it unnecessary for the union to win a majority of that larger group. They just now need a majority of whatever smaller bargaining unit they request. And we have seen this happen all over the country. Volkswagen, some of you may have heard about, hopefully not for the emissions issue, but they have a factory in Tennessee where there was a union election last year. The union was seeking a bargaining unit of roughly 1,200 employees, and they lost. So they came back at the end of last year saying, actually, we just want this unit of 160 people that are the maintenance employees. And they won that election. So now they represent people in the factory. They can now access the factory anytime they wish because they do represent employees there. So it enables them to get that foothold. Macy's, there was a case there involving cosmetics employees. So the union did want to represent the sales associates, but they didn't want to represent all of them, just a small subset. And they were able to win that election as well. Panera Bread, company you all may have heard of, there was a case in Michigan where a Panera franchise had 6 or 7 restaurants. The union came in and decided they wanted to organize at just 5 of them, not all 6 of them, and they only wanted a couple of the actual bakers, not everybody in each of those restaurants. And the board decided, yeah, okay, sure, that's an appropriate bargaining unit, and allowed the election to take place. So bottom line with this issue here is that the board is attempting, again, to make it easier for unions to organize, shrinking down the size of those bargaining units, and in a number of workplaces where employers, I think, kind of thought, well, this is what the appropriate unit would be for my workplace. It turned out maybe it isn't. So just another thing to keep in mind. I did want to close with the overtime rule because this is getting a lot of attention. It's not necessarily a union-oriented rule, and it's coming out of the Department of Labor, but it could have some very, very serious impacts on how businesses run their operations and how they pay their employees. So right now, this is a proposed rule. Okay, we don't know what the final rule will look like. The proposal was issued June 30th of last year. We're expecting a final rule probably sometime in the late summer. The Department of Labor is working like crazy to get this final rule done, but we're just not there yet. So we don't know what will be in the final. We need to base our discussion off of what we saw in the proposed rule and what we know is in that. So the first thing we know is that the department wants to raise the salary level test for employees to determine overtime eligibility. And I just want to make sure we're clear about which employees we're talking about here. So hourly employees, we know they already are eligible for overtime. That's not an issue here. These are salaried employees, white-collar employees who qualify for exemptions as either executive, administrative, or professional employees. That's the subset we're talking about here. Right now, to be eligible for overtime, you need to make less than $23,660 per year. If you do that, if you make less than that, you're not going to qualify under the salary level test, right? You would be eligible for overtime. But if you make more than that, then we need to look at some other issues, but potentially you would be exempt. Well, the department is going to, or wants to, raise that threshold pretty dramatically, about 113%, up to $50,440 a year. So if you made less than that, and you qualify for those exemptions as executive, administrative, or professional, you would be now eligible for overtime. Now, $50,000 a year in Manhattan or San Francisco, yeah, that's not that much, but Montana, Arkansas, Missouri, a lot of other states, yeah, $50,000 is not a bad salary, and if you're making that much, you are probably a managerial employee of one form or another. Well, now the department, at least in the proposed rule, is telling you that you would actually go back to punching a time clock and you would be eligible for overtime. Again, very dramatic increase, 113%. And by the way, there is no phase-in. Okay, this is not at least in the proposed rule, there is no phase-in. So it's not that this raises over time, maybe 3 or 4 years. It goes into effect the instant the rule becomes final and its implementation date hits. Suddenly that salary level will jump up overnight by 113%. They've also increased the highly compensated test. This applies to a much smaller subset of employees, but basically under the rule you've got the $23,660 level and you've got the $100,000 level. If you make more than $100,000, the presumption is, hey, you're not going to be eligible for overtime, right? Whatever you're doing for your job, you're not going to qualify. So there's a very simple test to determine eligibility. Well, the department wants to raise that to $122,000. So you may have a manager who's making $114,000 a year. Suddenly now that person is back to, okay, do I meet this test? Do I meet that test? They're no longer eligible for that very short test. So potentially they could actually be eligible for overtime, even though they're making $114,000 a year. So it seems a little bit ridiculous, but that is also in the proposed rule. Now they've also included an annual adjustment of one form or another. So that $50,000 level won't stay there. It will go up every year. We don't know the exact methodology they'll use, but we do know that it has the potential to ratchet up very, very quickly if they do this the wrong way, and it looks like they probably will. So within a matter of 5 years, you could see that 50,000 level as high as 90,000. So your eligibility pool for overtime will likely go up fairly quickly. Now, in the proposed rule, the department did something interesting with regard to the duties tests, okay? And this is that third test that you need to meet to determine eligibility, right? So are the duties you are performing executive, administrative, or professional in nature? If they are, again, you're not going to be eligible for overtime. So we don't know what changes the department will make in this duties test because, again, in the proposed rule, they did something interesting. They didn't propose a specific change. What they did was they asked a series of questions. Should we think about doing this? Should we think about this? What about this issue over here? So what I think the department is hoping is that when they issue the final rule, they can make the salary change that they want and then kind of bootstrap those questions into the rule and propose whatever change to the duties test they were thinking about making all along. Now, I think the reason they asked just those series of questions is because, frankly, this isn't easy, okay? I mean, it's difficult to define those duties tests. I went through this process in 2004 when the Department of Labor changed the overtime rule, and it's hard, okay? I understand that. That's why it took us 4 years to get a final rule done. Well, these guys don't have 4 years, okay? They've only got 1. So that's why I think they decided to do this somewhat unorthodox approach of just asking these questions. So again, we don't know what the changes to the duties test will be. My guess is we'll see some kind of cap put on the amount of non-exempt duties you can perform before you would lose the exemption. We don't know what that cap might be. Maybe it's 50%. The other thing we'll probably see is some change to the concurrent duties test, which simply says that can you walk and chew gum at the same time, right? If you're the manager at a 7-Eleven, you're probably not managing the whole time, right? Sometime you might be stocking the shelves, you might be cleaning up a little bit, but overall you're still the manager, right? If there's an incident that requires managerial attention, you're the one providing it. So the current rule recognizes that concept of concurrent duties. We don't know if the department will attempt to change that. My guess is they probably will in some way, shape, or form. But again, we don't know because all we've seen are those questions that were asked. So this is always a thorny issue for employers. How do you deal with people who are working from home, people who have mobile technology? How are you going to track that time? If you've got a manager who is making $50,000 a year, has an iPhone or laptop or whatever device it is that you've given them to use for work, well, there may be some days where they're working from home, or maybe they do that on a regular basis. But you need to figure out how you're going to track that time if they suddenly became eligible for overtime, because even if you don't know that they're working from home, you're still responsible for the time. And hopefully they're good enough that they will report it accurately, but maybe not. It opens you up to the potential for some serious litigation on overtime issues, and that is a favorite avenue for the trial lawyers to take on. So employers will have to think about how they manage those devices and how they manage that time, and I don't think there's a great answer for that just yet. All right. This is the slide I always like to conclude with because, frankly, the previous ones are a little depressing. So this gives us some sense of things that we can do to fight this stuff. So first, of course, is to get educated on the issues. There's blue folders on your chairs. There's a report we did on the handbook issues. So go ahead and take those with you, and you can read them when you're really bored one night. But this is critical here to talk to Congress about these issues. And in particular, in a state like Montana, Senator Tester is one of the folks that the business community sometimes will reach out to on issues like these because he's not so far to the left that he doesn't want to listen. So it's very, very important that people reach out to him and talk to him about these issues. When we're in D.C. With the U.S. Chamber, we go to lobby members. One of the frequent things we'll hear is, I haven't heard from my constituents on this issue. Okay, well, you all are the constituents, so it's very, very important that your members of Congress hear from you on these issues, in particular on labor issues, because they're not ones that tend to grab a lot of headlines. And so if members don't hear about them, they're just going to assume that people don't care and that these issues don't matter. So it's very, very important to do that outreach on all of these issues. There are certain bills that have been introduced in Congress to overturn some of this stuff. Frankly, they're not going anywhere at this point in time. But what does have the potential to impact this stuff on the legislative front is appropriations riders. Last year, there were a number of appropriations riders put into the labor piece of the larger omnibus spending bill that would have restricted the board from pursuing some of these policies, and is very, very important that we look to do those again in the current fiscal year, in the current appropriations process that will start up in 2016. So as that process goes along, it's very, very critical to reach out to members of Congress and tell them, hey, if there are policy riders that would prevent the board from using funds to pursue the joint employer standard, for example, we need you to support those. We did get a decent level of support amongst Democrats on that joint employer rider last year. We'd love to see that done again. So please do take advantage of the opportunity you have here in a state like Montana to reach out to your members. Obviously by phone. There's district offices here you can contact. You can submit letters to Congress. In a state like Montana, I think you can probably just pick up the phone and call your senator, right? They know all of you on a first-name basis. So please take advantage of that. And as you all are here with the state chamber, I think that's great. We always urge people to stay involved with the state chambers, with your local chambers, and with the U.S. Chamber as well. So that is my presentation. I guess you want to do questions now, or?
Well, I thought we'd just see if we have one or two questions, and if not, we'll just jump into Connie's presentation, have them at the end. But if you have something fresh in your mind for Glenn right now, any questions? Yes.
You talked a little bit about the handbook issue stuff, and I'm thinking from a nonprofit perspective. I'm a board chair of a couple, and how do you know what you can and cannot say in that handbook?
Well, that's a really good question, and unfortunately I don't have a good answer. The General Counsel's Office did put out a guidance document last year, which you can get off the NLRB's website, and it might be a good thing to take a look at. Unfortunately, it raises a lot of questions, in some cases more questions than it answers, because it will have policy language that it says is unlawful, which looks almost completely identical to policy language they say is lawful. So how an employer is supposed to know is really open to question. I think the larger question here is why on earth is the board actually pursuing these cases to begin with? And I think, one, it's because they do have the potential to allow the board to do rerun elections if a union loses. That's sort of the cynical, or I guess that's sort of the sinister interpretation. The cynical interpretation, which I think is probably more accurate, is that the board simply doesn't have enough to do. You know, the number of union elections they conduct and unfair labor practices they've been filing in the purely union space is down pretty dramatically. So they are simply looking for things to do. Their budget has stayed pretty much flat for the last decade, even though their workload is down. So, you know, they need to justify their budget to Congress just like anybody else.
You know, I'll use that question to segue to Connie, because in our own little company a few years ago, we had an employee handbook that we had we'd done, due diligence. We'd consulted with the internet and we'd found an employee handbook online. And what could go wrong? And actually, fortunately, before anything did go wrong, we had joined an association here in Montana, Associated Employers, that's been around
100 years.
100 years, yeah. And they actually have folks like Connie. We use the person on this side of the state. Connie's over in Missoula, but to help us rewrite our handbook, because in Montana you can get in a world of hurt by having the wrong stuff in the wrong place in your handbook, not following it, all that. And we were guilty of all of those things. And Connie Kulbeck has been with Associated Employers for a number of years, but she had a period when you were gone for a number of years. Now you've been back about 3 years. And they say that if you can't do it, teach it. If you can't teach it, consult it. But Connie's one of those individuals that can do it all. She's actually been in the HR front lines herself for employers, has consulted, and as far as I know, you probably taught it too, Connie. I don't know, but
I haven't. I'll try not to do that today.
Okay, but anyhow, without a lot of I should mention, because it was part of my materials here, we're supposed to talk just a bit about sponsors, and we do appreciate the fact that Associated Employers is helping sponsor this conference. And so Connie's going to talk to us about Montana laws, what's going on, and maybe what the future holds. So, Connie?
Okay, thank you. So thank you all for coming today and listening to this. I'm glad that Glenn took the tough topics, what's new, because that really is what's new for employers in Montana. And of course, we always have to follow the federal rules, and then we do have some specific and unique laws that have been passed over the last few years in Montana. And so I'll try to just point out the little differences or nuances or things that we are seeing at Associated Employers, because we do review a lot of handbooks, so we have to pay attention to what's happening at the federal level and do our best to kind of help give guidance. But I'll try not to teach today and just take the time that we were allowed to tell you what we're seeing as being different and where to look and things to think about in your organization. So I'd like to talk a little bit about the Fair Labor Standards Act that Glenn just talked about with the overtime rules. And some of us are not doing what we should be doing today. The one statistic I've seen on the Department of Labor website is that 70% of employers are out of compliance already with those individuals that they're not paying overtime. So, and there's good reasons why people have considered positions to be salaried. We may have a person who's working in our organization who has a master's degree. But it's the question we have to ask ourselves, is the work they're doing, does it require a master's degree, and particularly in that field? And that's why that duties test needs to be done on all positions that we have. Sometimes we give people titles and we play with the exempt and the non-exempt because we want to be respectful of their professional status in the organization. So I don't think as employers we necessarily intend to not follow the law, but we get caught up in that. Or jobs change over time. So as people are trying to figure out what's going to happen, and we've been in limbo now for a long period of time for us, wondering when this law is going to drop in because we know it's immediate. Some employers have called us and said, now my employees are telling me that this means that I immediately get an increase in pay because I'm a salaried employee, and now I will go from the $23,660 to the $50,440. So we have some tension out there. And what we're telling people is make sure that your job descriptions are in place and start studying that now, because something is going to happen. Because where we are today is probably not the right thing to do, and both our states and our federal governments are trying to, balance the employer and the employee rights, and there may be some abuse at the $23,660. The definition and also the payment rate has slightly different language in Montana law, and so we like to, whenever we have the opportunity with groups, to remind them to go look in the Montana law because it is a little bit different than the federal law. It's a little bit stricter and since it's stricter, it's the law that we have to live with on the computer-related language in Montana. And again, we have the employee relations issues that surround computer people. We know how those folks like to work and when they like to work and how much time they like to spend so that they don't have deadlines. And so it's a difficult discussion to have with your employees as well as complying with the law. Montana Wrongful Discharge from Employment Act is the one that when new employers come to Montana, they're frightened of. And actually, after we have some discussion about the benefits of that particular law, that level of anxiety, I think, does come down, because we are only at will in the first 6 months of employment or any other probationary period that's been designated by the employer. The default is 6 months. And what we're seeing as far as trends in the length of the probationary period is that they're becoming longer for those employers who feel that they can justify that the particular position, it takes a longer term in order to be able to determine if that's a good fit for that particular job. So if you think about an accountant where their work is secular, and they may do things monthly, quarterly, and annually, that probably makes sense. However, if we're hiring a customer service rep, 6 months may be the time frame that's appropriate for that particular position, and you can have different probationary periods. It's harder to communicate and to work with, particularly if you have an employee handbook that's in place, but it's certainly something that we can do. And we do have to establish good cause after the 6 months, and I think most employers, they operate, we want to do the right thing. Our labor force is a little bit short today, particularly in some areas, and so we don't want to willy-nilly terminate employees from our workplace. We just have to use good process and always remember to follow whatever it is we have put in writing. And besides our handbooks, it's everything else we have in writing, every memo, every email, and the conversations that we've had with individuals all come into play. You do have to have a grievance procedure if you want to give your company the best protection you can, because if the employee who is discharged from employment doesn't follow the grievance procedure, then that gives you an edge, and you may be able to get summary judgment when you go to district court. The Montana Maternity Act is a little bit broader than your federal laws, and so what we're seeing from our purview is that people may not be as familiar with Montana maternity and believe that if they have less than 50 employees, there's no law that they have to follow. Reasonable, and I enjoyed Glenn's definitions of reasonable. Reasonable for maternity leave could be as long as a year. If you have someone who starts off with a difficult pregnancy and that continues on, that's a long period of time, where the federal law is at 12 weeks for the benefits that you need to give. And then, of course, we're going to somehow work into the ADA. So what we're seeing trend-wise is that the laws that we have in place are starting to overlap, and it makes lawsuits or sorting it out as an employer pretty interesting process. The exception, for private employers, sometimes we're so small and our situation is so specific that we can claim an undue hardship in Montana. That's a little bit different than the federal law as well. Want to be careful, want to have a good attorney when you start into those processes of sorting out the things under the laws. In Montana, we passed a drug testing law. It's a voluntary program. Employers don't have to do it. However, it's been very helpful for those organizations who are required to do background screens and do drug testing, because it gives us the guidance that we didn't have before. So we had a requirement, and now we have the guidance to do it. It follows very much what DOT or your commercial drivers followed. The lab testing is the same. And if you want to implement a policy, there is a requirement that we give employees 60 days after we notify them that we're going to start drug testing in our organization. And that's one way that our legislature tried to balance the employee and the employer rights going forward. And we also get to determine the sanctions, so we don't have to terminate someone. We can have alternatives for those who do turn up with a positive drug screen. Can we test all employees in Montana? The answer is no. And these are the three categories. This is my teaching, just to give you a refresher course. Because what we see in Montana is normally if an employer decides to test, they're testing all employees, and that might not be the best practice to use. So again, those job descriptions that we use for determining if someone is subject to minimum wage and overtime are also very helpful when we're doing our drug testing, and we should designate which employees are so that they know, and that may prevent us from some additional workload that we have to do when that employee leaves our work environment. It does not allow for independent contractors to be tested, and I thought that was pretty important to just share. It's something that we think is not well known. Sometimes you'll have subcontractors that come in, and so they've been doing the drug testing under the employer's policy, and that doesn't quite work. So got to think through how, and it's easy for the independent contractor to get their system up and running too, so that they can help. Just a reminder of what the different tests that you can do. And reasonable suspicion is the only one where you have to have your supervisors trained prior to doing legal reasonable suspicion testing. The Human Rights Act, and that's the one that was the most interesting as I was thinking about the slides and the information here today, that you see change. In the fall, I went to a seminar that was put on by a law firm in Missoula, and they said retaliation is the #1 claim now at Human Rights. And so that was interesting, that retaliation is, and as they talked about the definition for retaliation. And we're seeing usually when employees used to file their human rights complaint, it was 1 or 2 issues. They might say age and sex for their discrimination. But now we're seeing the wrongful termination, so the employment and the discharge issues coming in with the human rights complaint. And I went back 2015, 2014, and you can kind of see how that's ramping up and that's getting to be a broader classification. Probably because then, as the hearing goes forward with your human rights case, the attorneys can get an idea of what things might make it. It gets sorted out at that level, which is a less expensive level than after they file in district court. Montana marital status, just a reminder here today, sometimes our nepotism policies in our handbook are a little restrictive, and there needs to be a good business reason for not allowing people to work in your organization or choosing not to select someone who is a member of the family, particularly a spouse in the marital status case. Harassment and hostile workplace claims, the change that I have seen is in what is considered in the hostile work environment. The sexual harassment is still pretty clear, and we've had that law in the books long enough that we understand it, and we know we have pretty good guidance on what's okay and not okay. And so when we conduct those investigations, we get to sort that out pretty well. Bullying claims are sort of our new area of trying to understand and as an employer figure out what is bullying and what is just being mean, and that's challenging. Here's all the different areas where an employer can, and it's not all inclusive, I'm sure there's others too, but the main ones where we find ourselves in trouble either with discrimination or retaliation. And I have a specific slide on retaliation since that's the biggest change. It is something that we have to be very mindful of today because the claims are real high risk. Remember with Montana wrongful termination, when that law was passed in 1987, it limited the damages. That was the exclusive remedy for employers who were discharged. And if we can get it through the Human Rights Bureau and get a retaliation claim attached to any other claim, there's big dollars to be gained in that particular area. It's such an emotional issue when we hurt people's feelings, and we do those types of things that, of course, we like to get, the employee likes to get it into a jury trial. It's an evolving area and probably one that we're going to be living through for several years as we get that figured out, much like many of the other laws that get started. Harassment's based on protected sex or protected status, and sexual harassment, of course, has the undertones of the quid pro quo, and bullying does not. And there hasn't been any specific federal legislation that's passed. The Montana legislature last year dealt with it more in terms of a more general, trying to define and give definition to it, but not any real specific things that employers are required to do differently today. Just a tip, if you're thinking about using the word bullying in your employee handbook, think more about, don't put it in your harassment, sexual harassment, and your discrimination policies, but treat it differently. If you have violence, workplace violence policies, some I see are trying to write language there, but you certainly want to have your attorney involved in that because it's going to be an evolving area of change, and we got to stay in tune with our labor attorneys and make sure that if we're going to put that language in the book, we're going to do it. A little bit of humor there. One attorney at a workshop said, you know, since it is an equal opportunity harassment thing to be a bully, she said she's actually been able to defend companies where the person was a bully to everyone, just a mean person, but you can't just be mean to one person. ADA, the Americans with Disability Act, has had some changes the last couple of years and was amended, and alcoholism is probably the one that we may have missed in the first review of the changes, but alcoholism is covered under the ADA. Now the person still has to come to work, they still have to do all of your conduct and performance standards, but they have a level of protection that those who are drug users do not. And so we have to pay attention to that, difference being the illegal drugs and the alcohol being legal. We got great tools today when dealing with Americans with Disability Act because they come into the pregnancy, they come into Montana Wrongful Termination Act. Thinking before you discharge someone, you probably want to look at the interactive process if you're, depending on what you're firing the person for. But we have lots more tools today for the interactive process, and if you use the JAN work site job accommodation network, it's got great tools, and most of us have difficulty dealing with the mental health disabilities. The stress in the work environment, the pace with which we ask people to do their work. People are asking for an accommodations. Sometimes people can't work in cubicles. You have really good guidance on that website to give you some ideas so they can have the right discussion. Current job descriptions, you know, that's always at the top of the list for any laws that you're dealing with. Having an effective internal process that you use, and training your managers, and just be alert because the ADA cases are very expensive. I don't know how many are actually being filed in the district courts because we don't have a good tracking mechanism for that. The human rights, if you go out to their website, you can see the number of cases that also have ADA attached to their cases. So we just got to be aware and alert and watch for the signs. So as employers, you know, if we do everything we can to hire the right people, we think we've made a perfect choice. We just got to get better at that. And my tip there is spend more time on the hiring process than you've ever spent before. And then take advantage of your probationary period. Get them started off right. Pay close attention to what's going on there. Provide a safe environment, and that's more than just facilities and equipment. We also want to provide a safe environment where people are comfortable talking to us so that if there is an issue out there, we've got a forum for them to come forward and talk to us so we have an opportunity as an employer to address it before it becomes a big deal. Communicate, communicate, communicate. I think you've probably heard that everywhere you've ever been because that's how we learn things. Listen differently, listen differently, listen differently. Because we got to look at it from each individual's point of view. Manage performance every day. Sometimes we're the perfect employee for 22 years. We have something happen in our personal life. It does flow over into our work life, and we want to address it immediately and help them find their outside resources because those are the things that become our expensive cases later on. And document, document, and document. The last Montana Wrongful Termination Act, or Montana wrongful discharge from employment act case that I could find with the resources of the Montana Law Library was actually filed in 2013. So it's been a while. There may be others. That's the Supreme Court. There may be others that are in the district courts, but again, there's not a tracking mechanism that's easy for us to find. So I think that's all I have today. Thank you.
Great. Well, thank you, Connie. And we have a few minutes for questions. Then at 10:30, there'll be a break at 10:15. 10:30, there's 2 other breakout sessions. And then at noon, Congressman Zinke will be speaking over the luncheon. So just taking a few minutes here. Any questions, comments? Yes.
What kind of communication are you giving to your clients in regard to the whole medical marijuana piece when you talk about drug testing?
Well, the conversations that we're having are from employers who have been drug testing. And because of the issue of marijuana, they're rethinking their drug testing policies. Maybe they're still doing pre-employment, but they're no longer doing random. And then they're trying to do good performance management and pay attention to how everybody shows up every day and can they safely perform their work rather than using a testing tool.
Is there an employee obligation to inform the employer that they in fact have a medical marijuana card?
Well, if the employer has a drug-free workplace and an employee notifies us that they have the medical marijuana card, we still, if we're drug-free, they probably can't work for us. Now, that depends on what your drug testing policy is and how you've defined it and what the rules are, but they would probably not be in compliance with your rules if they're a regular user. Yes?
Yeah, I was going to ask, Glenn, thanks for making it over here. As everybody's looking at the DOL and the proposed rule, I want to say, what are the chances, and particularly in this comment period before they come up with the final rule, of instead of going at $455 a week or the $23,000 to the $50,000, could there be a more? Because maybe even as employers, the business community could agree that $455 a week for all these years is probably low as a task. Can there be a $30,000, $35,000 a year? Could you imagine that being? And as employers that are advocating for common sense regulations, is that a possibility there?
Well, sure, anything's possible because the final rule isn't out yet. And certainly in the comments that the U.S. Chamber submitted and that a lot of other groups submitted, we did make that point, that this is a very dramatic increase. You might want to think about scaling it back. The annual adjustment you need to think about as well, whether that's, A, whether Congress intended for you to be able to put an annual adjustment in, and B, if you're going to use it, that you use the right methodology. So, yeah, anything's possible. I mean, the department could decide that, we're going to scale it back to $30,000. I don't think that's likely. I'd suspect the final rule will come out fairly close to that 50,000 figure. Again, we don't know exactly what. It's not like they're calling us up and telling us what they're thinking, but I wouldn't anticipate the final rule being a lot different from what's in the proposed, with the exception of they will actually tell us what the duties test change will be. But certainly the business community has been working very hard to try and get some more reasonable, a more reasonable rule in place.
Terry?
Just a comment, actually, employment at will, just so employers understand how that is really affecting our state and recruitment to our state. I just did a white paper for the Chamber Board on it. All 50 states are employment at will states. Montana is the only state that puts a time frame on it. That's 6 months. The only state. So after 6 months, now you're at cause. Also, I've read about 10 states so far. I'm not through all the states on penalties and that sort of thing. What I can find so far is Montana is the most restrictive on penalties. Montana, as far as I can find, is the only one that allows punitive damages on a wrongful discharge. So far. That's all the states around us, and then some of the fastest growing states like Florida and Texas and stuff like that. We are one of the most restrictive states on the criminal period.
True.
Glenn, have there been any changes on the rules for decertifying?
No. No, those rules have remained in place. There was a change with regard to elections under the Railway Labor Act, and that may have touched on some of the DCERT stuff. But as far as the National Labor Relations Act, no, there's been no change on the DCERT procedures.
And what's the percentage that's required then?
For a decertification, it's the majority of those who show up. So that the employees will need to demonstrate that there is a showing of interest. I think that figures 30% of the bargaining unit would have to indicate in some way, shape, or form that they don't want the union anymore, and then the employer can go to the board and say, hey, we've had this indication that there's not support, and then the board will come in and hold an election similar to what they do for certification elections, and if a majority of voters that show up decide they don't want the union, then they're decertified. Yes, I don't anticipate we'll see any change in that either.
I think we have time for, another question, anyone?
For Glenn or Connie, kind of a general question. Connie, you made a statement about get legal counsel before you start any of these processes, et cetera. I work with employee benefits, and a lot of mid-sized or smaller employers kind of reluctant to call the attorney and spend the money. What's your recommendation? How do you recommend what counsel an employer should have, or are there resources that kind of point the employer in the right direction?
Well, we always recommend that you not use necessarily the attorney that helped you put your corporation together, that you actually get one that works in the area of employment law. And most of your law firms have a group or one person who that is the work that they do. Because we have all these evolving issues, we think it's important that you do that. And what we try to do for our members, because they are small and their budgets are small, is we try to help them think it through, sort it out, be able to describe the policy they need to work within their organization, so that when they sit down with the attorney to draft their language or to have the attorney review what they have written, they can do it in the most economical way.
Yeah, I think Connie made a really good point about finding the attorneys who work in this field, because it is becoming so complex, and we only touched on a few of the changes at the federal level. I mean, there's much, much more that we could get into. So, yeah, you need to find someone who really specializes in that field.
I was teasing beforehand that with Glenn that next year under President Sanders, I'm sure we'll have much better Department of Labor rulings. But teasing aside, I mean, there's a lot going on here. Most of it's not favorable toward employers. My own commentary 16 years ago, moved to Montana, took over a division of a company, had a couple of people that everybody knew were just bad actors. One had alcohol problem, plus issues that predated that, et cetera. Went to our human resource department. I was probably 6 weeks into Montana, and was just floored by their attitude. So I quickly went to our general counsel. I said, this is ridiculous. Our HR people are saying this. I said, yeah, that's right. And I would just tell you that coming in, now what's interesting for me, 16 years later, it doesn't shock me anymore. But at one time, I remember thinking, we have got to get these laws changed. I hope somebody is trying to change some things here. So I think we've all learned to accommodate it. It is, I don't know what can be done in the realm of political possibility, but we have people within the Montana Chamber that are experts on that. But I would say that coming from other states where it is true employment at will on both sides, the employee can quit with 2 weeks' notice, and the employer can take job action that's reasonable, not harassment. I've never met an employer who wanted to do that, although I'm sure there are some bad actors on the employer side out there. But I would love to see what Terry talked about, have that's been surfaced within the Montana Chamber. Everyone in this room is here for a reason. You're interested in this. If you're not serving on the Montana Chamber Board, if you know a board member, please go to them, get information. Terry's in the back of the room. I'd love to see this become a priority in an area that we can have an impact on, which is right here in Montana. Nationally, a takeaway, Glenn, I'm just going to take for everybody here. If you happen to bump into Senator Tester at the Salt Lake City airport one day, as I think many of us do, it might be a topic for discussion, and we'll be glad to stay in touch with you so we know exactly how to bring that up so we're relevant. But again, thank you both Glenn and Connie for coming and being with us today. I wish I could say we have a big stipend for you, but I think we do have lunch. So again, thanks everybody. And